Hello viewers, today's topic of discussion is conditions and warranties. In this lecture, you will be able to understand concept of conditions in contract of sale, implied conditions, concept of warranties in contract, conditions to be treated as warranties, implied warranties. The parties are at a liberty to enter into the contract with any terms they please. As a rule, before a contract of sale is concluded, certain statements may amount to stipulation forming part of contract or mere expression of opinion which is not a part of contract. If it is a statement by the seller on the reliance of which the buyer makes a contract, it will amount to stipulation. If it is mere recommendation by the seller of his goods, it does not amount to stipulation and give rise to right to action. The stipulation may be related to nature, subject matter, time for performance of the contract. Section 12 draws a clear distinction between a condition and warranty. The stipulation may be condition or a warranty. Some of these terms may form basis of the contract and have to be necessarily be performed, and these are called conditions. Some of them are incidental or collateral to the contract and may not be crucial to the contract. These terms are called warranties. It is important for the parties to correctly identify which terms are to be conditions and which are to be warranties. Where there has been a breach of contract, it is important to determine which type of term has been breached in order to establish the remedy available. Now we will discuss the condition. A condition is a major term of the contract which goes to the roots of the contract. If a condition is breached, the innocent party is entitled to repudiate the contract and claim damage. It was held in Posad versus Spires. An example of the condition is the term that entitles the buyer to vacant possession of the property. If the seller is unable to deliver vacant possession and it is a breach of conditions, then the buyer may have the right to affirm the contract and sue for damage, for default and sue for specific performance or terminate the contract. Thus, every contract has a certain terms and conditions which the parties have agreed to fulfill. These conditions are called express conditions, and the parties are free to include any number of express conditions. But in addition to these express conditions, there are other conditions which, though not express, may be read into the contract unless they are expressly excluded. There are several conditions recognized under the Sale of Goods Act which are implied conditions. Now we will discuss implied conditions. The implied conditions may be as to title, goods shall correspond with the description, quality or fitness. Conditions as to the title. Section 14 of the Sale of Goods Act says that the essence of sale being the transfer of the title. It is one of the duties of the seller to ensure that he has a right to sell what he purports to sell. That's why the law reads into every sale the implied condition that the seller has the right to sell. If the seller's title turns out to be defective, then the buyer may reject the goods. In Rowland versus Devel, the plaintiff purchased a second-hand car from a dealer. He used this car for some months and it was then seized by the police as a stolen one. The court held that the plaintiff can recover full price from the seller even though he had used the car for some months. Lord Atkin said, I quote, "There can be no sale at all of goods which the seller has no right to sell. The whole object of the sale is to transfer property from one person to another. In fact, buyer has not received any part of that which he contracted to receive, namely the property and the right to possession, and that so there has been total failure of condition." Unquote. In certain situation, the seller may be the owner of the goods, yet he may not have right to pass the property. If that is the situation, the seller may be said to have committed breach of conditions as to title. This was happened in Niblet versus Confectionaries Material Company. The defendant sold the plaintiff 3,000 tins of condensed milk. On their arrival in England from New York, it was found that 1,000 tins were labeled as Nestle brand. Another manufacturer of a condensed milk under the name of Nestle brand claimed that this was an infringement of his trademark. The plaintiff has to remove all the labels in order to obtain the goods and subsequently sold them at reduced value. He sued the seller for the breach of the condition as to title. Lord Atkin explained the legal position. He said, I quote, "The seller had admitted that he had committed infringement of the Nestle company's trademark. He was liable to an injunction restraining the sale. Therefore, he had no right to sell these goods at the time when property was to pass. Thus, the seller has committed breach of conditions as to title." Unquote. Now, we will discuss the implied condition in sale by description. Under Section 15 of Sale of Goods Act, where there is a contract of sale of goods by description, there is an implied condition that the goods shall correspond with the description. Two things are necessary to enable a buyer to invoke the protection of this section. Firstly, there should be a sale by description. Secondly, the goods should not correspond with the description. The expression sale by description includes many situations. Lord Wright pointed out in Grant versus Australian Knitting Mills by saying that there is a sale by description even though the buyer is buying something displayed before him on the counter. A thing is sold by description though it is specific so long as it is sold not merely as a specific thing, but a thing corresponds to the description. Example, woolen garments, hot water bottle, a second-hand reaping machine. Sale by description includes a variety of situations, but it is not possible to lay down any exhaustive list. An obvious example is where the buyer has never seen the goods but buys them on the basis of the description given by the seller. This happened in Warley versus Whip. In this case, the buyer purchased a reaping machine which he had never seen. The seller told the buyer that the machine is almost new as it had been purchased only last year and was used to cut grass only for 50 to 60 acres of land. When the machine was delivered to the buyer, he found it extremely old and therefore returned it. The seller's action against the buyer for the price failed. It was held that the sale is by correspond with the description. Where the buyer has seen the goods, it may be the sale by description if he relies not only what he has seen but what he has stated to him, and the deviation from the goods is not apparent. Nicholson and Venn versus Smith Marriott. There was a sale of antiques. The plaintiff purchased a set of linen napkins and a tablecloth, describing as dating from 17th century. He afterwards discovered that these goods were of 18th century and sought to reject them. The court held that the goods could be rejected as plaintiff had lied on the defendant's description, which turns out to be false and could not have discovered by the casual examination. Where packing of the goods is crucial to the contract, it may sometimes be considered as a part of description. This was illustrated by Maury and Company versus Landor Company. The plaintiff purchased 3,000 tins of canned fruit from Australia to be packed in cases each containing 30 tins. The seller supplied a bulk in cases containing 24 tins. The method of packing was held to be the part of the description and therefore the purchaser was entitled to reject the whole consignment. Implied condition in sale by sample. The second part of Section 15 further provides that if the sale is by sample as well as by description, it is not sufficient that the bulk of goods corresponds with the sample. If the goods do not also correspond with the description, the goods should not only agree with the sample but should correspond with the description also. In an old case of Asmar versus Kassler, long staple semen cotton was sold as equal to sample. The contract provided that if the goods proved inferior in quality, a reasonable allowance would be made to the buyer. The cotton supplied was not long staple cotton, but only Western Madras cotton. The buyer was held not to be bound to accept the goods. Implied condition by trade usage. It is an age-old practice of a business community to have their own usage of trade. The usage has been recognized by the courts as in goods as any other law on the subject. Section 16 subsection 3 gives statutory force to the conditions implied by the usage of a particular trade. It provides that an implied warranty or a condition as to quality or fitness for a particular purpose may be enacted by the usage of trade. This provision was applied in Jones versus Bowden. There was an usage in a sale by auction of the drugs that if they were sea damaged, then that has to be expressed in a seller's catalog. The seller was in this case exhibited sample of the quality but does not disclose that they were sea damaged. It was held that this was equivalent to saying that they were not sea damaged. Now we will discuss the warranties. Warranties are the minor terms of the contract which are not central to the existence of the contract. If a warranty is breached, the innocent party may claim damages but cannot end the contract. It was held in Bitney versus G. An example of the warranty is where the seller warrants or agrees that the settlement of the property will be in the same state and the condition it was an immediate before the date of contract. There may be a change in a physical feature of the property between the date of the contract and the settlement that the seller is not willing to ratify. In this instance, the buyer normally does not have a right to terminate or delay settlement unless the contract provides otherwise. Rather, the buyer must settle and separately pursue a claim for damages, compensation from the seller. There is no specific terminology which the party may use to express a term in their contract as a condition and warranty. Section 12 subsection 4 makes it clear that whether a stipulation in a contract of sale is a condition or a warranty depends in each case on construction of the contract. This legal position was further clarified by English court in Balde versus Marshall. The plaintiff informed the defendant, a motor car dealer, that he need a car suited for touring purposes. The defendant advised him to purchase a Bugatti car. The plaintiff acted upon his suggestion but later on discovered that this car was not suited for touring purposes and plaintiff sought to reject it. The defendant took the defense of the term in the contract which gives guarantee of 12 months against the mechanical defects and excludes every other guarantee or warranty. The court held that the suitability of the car for the touring purpose was not a guarantee or a warranty but a condition of a contract. The term forms the basis of the contract. Its non-fulfillment defeated the very purpose for which the plaintiff brought the car. He was therefore within his right to reject the car and have refunded the price. In Harrison versus Novel and Foster, the plaintiff brought two small ships from the defendant on the basis of an information furnished by the defendant that the dead weight capacity of each ship was 480 tons. The capacity was in fact less than 360 tons. The plaintiff sought to reject the ship. It was held that the representation of the capacity was not a condition but a warranty for which the plaintiff could have sued in damages had liability for warranties not excluded. Conditions to be treated as warranty. A buyer of a goods has an option to treat a condition in a contract as a warranty. He may not then treat the contract as repudiated. Instead, he is free to claim damages for a breach of warranty. Section 13 says, where a contract of sale is subject to any condition to be fulfilled by the seller, the buyer may waive the condition or elect to treat the breach of condition as a breach of warranty and does not give a ground for treating the contract as repudiated. Where a contract of sale is not severable and the buyer has accepted the goods or part of them, the breach of any condition to be fulfilled by the seller can only be treated as a breach of warranty and not as a ground for rejecting the goods and treating the contract as repudiated unless there is a contract express or implied to that effect. The buyer is said to have accepted the goods when, number first, he intimates to the seller that he has accepted them. Second, the goods have been delivered to him and he does any act in relation to them which is inconsistent with the ownership of the seller. Third, he retains the goods even after the lapse of the reasonable time without intimating to the seller that he has rejected them. In Hardy and Company versus Hilleran and Fowler, wheat was sold under an CIF contract, arrived at the port of destination. The buyer took up the shipping documents. The day on which the wheat was unloaded, they resold and dispatched a portion of it to sub-purchase. They found that the wheat was not of a contract quality and gave the seller a notice of rejection. This took 3 days only and in no case it can be said that a reasonable time has expired. The court held that the transfer of the possession to the sub-purchaser was an act inconsistent with the ownership of the sellers. This precluded the buyer from exercising his right of rejection. Implied warranties. Like implied condition, there are warranties also implied by law in every contract of sale of goods. These are: number first, quiet possession. Section 14 subsection 6 of the Sale of Goods Act says that in every contract of sale, unless there is an agreement to the contrary, there is an implied warranty that the buyer shall have and enjoy quiet possession of the goods. It is the responsibility of the vendor to ensure quiet possession of the goods by the buyer. If the possession of the buyer is disturbed by a person having a superior right than that of the seller, the buyer is entitled to hold the seller responsible for the breach of this warranty. Thus, in Rowland versus Devel, the plaintiff purchased a motor car from the defendants. The car turned out to be stolen property and the plaintiff had to restore it to the true owner. It was laid down that the buyer has not received any part of that which he contracted to receive, namely the property and the right to possession, and that being so, there has been a total failure of consideration. The court held that the defendant is liable to return the price of the car which he had received from the plaintiff in spite of the fact that the plaintiff had used the car for some months. Now second, free from encumbrances. Section 14 subsection 6 subclause C. The contract implied warranty is that the contract shall be free from any charge of encumbrances in favor of any third party not declared or known to the buyer before or at the time when the contract is made. For example, a person has pledged his goods and having taken them from the pledge under some pretense sells them, the goods being subject to the encumbrances. The warranty is broken and the buyer may recover compensation from the seller if his possession is disturbed by the pledge. Thus, from the above discussion, we can conclude that the conditions are important for the contract and gives right to the plaintiff to repudiate the contract. And in case of the warranty, they do not give any right to reject the contract. With this, we conclude today's lecture. Hope you have understood fully. Thank you.